So this is panel 5 on online social marketing and cognitive theory. And our speakers for the panel are Professor Dan Hunter, who is director of the Institute for Information Law and Policy at New York Law School. And then we'll be hearing from Professor William McGeveran from the University of Minnesota School of Law. And finally, Professor Eric Goldman, who is director of the High Tech Law Institute at Santa Clara University School of Law.
Okay, great, thanks. Is this on? That's the usual thing. Is this on? So thank you, everyone, for having me, for Case, for having me and us here for this last panel. Thank you, Jackie. Where's Jackie? Excellent, particularly for having us as the last speakers. It's always great to be the people standing between you and going home or having a drink. I need to make an apology. I entrusted the slides for this presentation to a research assistant who thinks of herself as an 18th century female novelist, alas. So what I wanted this particular presentation to be was about consumer decision-making, trademark law, and the domain namespace. Turns out to be Pride and Prejudice and Zombies, or Zombie Nets. It actually has nothing to do with zombie nets at all, but as you'll see in the slides, which I looked at with increasing degrees of unhappiness, but not enough time to change them, that she had either a psychic break, some kind of she was in a kind of a fugue state or something, and you'll see that this particular presentation is not tied very closely to the slides. They're more of sort of, well, they're not even an aid memoir, really. They're more sort of like a separate narrative that's going on, which at some point we'll try to drag back. At least she got my name right. So, so this particular presentation, right? It's actually much funnier if it had been in the font that I wanted to show this in. So this particular presentation comes about from a number of observations that I've had about the trademark system over the last couple of years. It's a paper that I've been working with Mark McKenna of Notre Dame, and the initial observation was that we sort of thought that the trademark system was the red-headed stepchild of the intellectual property, that no one was really looking at it very seriously, and that the sorts of questions that had been asked in relation to it were very different from the sort of questions that had been asked in relation to other regimes of intellectual property like copyright and patent, where there was a lot of foment about whether or not the system was operating properly and what the particular problems were. You know, we all know how the copyright system is critiqued by the intellectual property professoriate, the same with the patent system, and trademark seemed like a fairly dull kind of little backwater. It was a little strange that the nature of the problems that were being asked in relation to it were so narrow. This is not a criticism of the people that were doing it, but sort of if you look at, for example, the use debate that Stacey Dogan and Graham Dinwoody, sort of started to articulate this morning, it's not a debate about the sort of like the standard normative foundation of why the hell the trademark system operates. It's a discussion and a very learned and interesting one, but it's a discussion about one particular doctrine or one particular sort of approach to one part of the question. It's if you like, very, very narrow while being nonetheless still interesting. And so my question was, well, why is trademark so stable? Why is it that this red-headed stepchild that nobody's really looking at to ask what's going on? And my thesis, which I don't know that Mark McKenna shares, is that it represents a solved problem. That we all agree, at least in broad strokes, what the trademark system is for, and that broad agreement generates not very much argument, not very many problems, and that because trademark is a solved problem, we can sort of move on to other sort of smaller issues within trademark and those sorts of issues that might be in new questions that arise about the domain name system and so on. And when I say that it's a solved problem, what I'm suggesting is that that everybody agrees, by and large, that trademark is concerned with consumer confusion. Right? It's hard to say anymore, as once one could, sort of in about the 1940s, that trademark is really about unfair competition. that in fact these days Stacey's amusing little aside where she stuck the knife into Graham's ribs without him even really noticing it, about the Supreme Court agreeing with her about consumer confusion being the core of the trademark system was really sort of what we all agree, that really the trademark system should be about consumer confusion. It's not about the maintenance of business reputation. It's not about granting a property right in gross to trademark owners, even though sometimes we end up acting a little bit like that. And so this fact that it's all about consumer confusion gives rise to this huge amount of stability and really not much for us to talk about. What I want to suggest is that that this broad agreement masks a really fundamental problem in relation to the trademark system, and as we go through, we'll eventually end up at the point with something which I hadn't thought about before, which is that it also does undermine a lot of our understanding in relation to the domain name system. That is to say, the established verities of the domain name system in the UDRP and now all of these variants, the URS and others that we've heard about today, those are equally flawed, that we might want to investigate them a little bit more seriously. So let me give as quickly as I can, in embarrassingly quick absence of detail, the sketch about how we view consumer confusion. I won't go through the likelihood of confusion test. Many of you, all of you, I suspect, have heard it. If not all, then talk to me later about it. But consumer confusion is at the core of the trademark system, of the Lanham Act, and all of the state variants of that, and also largely, lots of common law countries. I won't try to talk about the civil law countries, but really consumer confusion is a thing that we care about. But what's happened after we accepted that consumer confusion was the actionable harm, that when we accepted that consumer confusion was the normative foundation of the trademark system, we lost sight of what the actionable harm of that consumer confusion was. That in fact, what's happened is that courts often, without even really thinking about it, will lose sight of the consumer being harmed at all and simply say, has a consumer been confused? And then move on from there to granting the plaintiff the injunction or the damages which he, she, or it seeks. And you sort of think, well, that's fine, right? Consumers shouldn't be confused. It's a bad thing. But when you think about it, that's a little strange, because people are confused all the time, right? And they don't necessarily lead to actionable harms. People are deceived all the time, and that doesn't lead to actionable harms within the trademark system. I can tell you that I'm the king of Belgium, right? Or offer to sell you the Brooklyn Bridge, or tell you that I'm going to respect you in the morning, but the Trademark Act doesn't care about that, right? It shouldn't care about that. Equally, a consumer might be confused in the sense of doing a double take and say, what? That strip club is Tiffany's, the jeweler? That doesn't, no, in the famous Posner conception of what trademark dilution was about, that doesn't make any sense. Tiffany's the jeweler hasn't moved into the adult entertainment field, to the best of my knowledge. Oh, of course, it's a joke / appropriation / whatever. There are lots of things where people are confused, consumers and potential consumers are confused, and the trademark system really has no role within those particular types of confusion. I can give you billions of other examples of confusion, but in a sense, if you think about it, human beings like being confused. We know this because human beings like humor. Humor is a joke. It relies upon, the cognitive science tells us, right, two different models of the world which intersect in a way that you go, whoa, oh, okay, I get it, and the gap is the funny thing. Take my wife, please, or take my ex-wife, my girlfriend, whatever, right? It's actually funny. Take my ex-wife, please, right, is funny because, right, initially it's the take my wife, right, and you go, okay, yeah, it's a reference to her, and then you say, no, I mean take her. It's actually challenging your initial conception of what I meant there and turning it into a joke as a result. Yes, I know we all know it, it's not funny, but it relies upon confusion. So the point about this is to try to say, well, consumer confusion isn't enough of itself. And there are like tons of examples that I can demonstrate for you that where judges have said, if confusion exists amongst consumers, there's automatically an injunction or damages which lie. And the easiest example to give you is initial interest confusion, right? I mean, we know this, the consumer is confused because she went to a website that was not controlled by the person that she thought it was being controlled by. And by the time she got there, she knew absolutely that this thing was the website owned by a competitor or some other site, and yet judges very quickly fall into line and created this doctrine, initial interest confusion, and lots of other examples that I can demonstrate to you. So the point about this is that I want to suggest that confusion of itself is not enough. So then what should the confusion relate to? Because I don't want to abandon confusion. I think confusion's fab. Right? So what does confusion relate to? And the confusion relates to the consumer purchasing decision. Right? To buy or not to buy, to do something in relation to it or not, right? And so in fact, what consumer confusion should be about is consumer decision making, not consumer confusion in and of itself. And with that, I can defend that later, but time is going to get away from me if we have to go into it in too much detail. But let me just say that is the thesis. That's the argument, that the trademark system has lost its moorings in thinking that consumer confusion of itself is enough. That in fact the only sort of consumer confusion that we should be concerned about is consumer confusion relating to purchasing decisions or other consumption decisions of various types. Okay. Music swells in the background. We all have a shiver up the back. And so who is the villain here? Well, in keeping with my ordinary tradition, the villain that I'd like to provide here is a law and economics one, because if ever there were a villainous bunch of thugs, it's the law and economics movement. So the villain here is of course, Richard Posner. Stacey Dogan, alas, is gone, but I'm going to lump her in there, Mark Lemley and others. But no, the villain here is the consumer search cost theory. The reason that it's a villain is that it provides a convenient law and economics cover for this particular problem of granting an actionable harm in confusion simpliciter. Consumer search cost theory, for those people who are not trademark geeks or trademark theory geeks, is the theory that says, this basically it's following on from what Stacey said this morning, most of which I don't disagree with her at all. That is that the trademark system is there to foster more innovation through providing better information to consumers and others. But the problem is that the way that the consumer search cost theory works is that the information processing capability or the information processing of a human being, right, is the thing that matters. So the reason that we have stability of trademarks over time, the reason that Coke, that Coke can up there needs to stay stable over time, or the brand needs to stay stable over time, is because I bought a Coke today, I liked it. Tomorrow I want to buy the same drink that I bought today because I liked it. I rely upon the brand as a proxy for quality and for making that consumer consumption decision of buying that same drink. The way that the law and economics approach characterizes that is that it's an information processing problem. That is, that the brand itself provides the mechanism by which I don't have to go and investigate the quality or who made that particular drink and so forth. Well, so far so unobjectionable. But what happens when you focus upon the search costs of the consumer rather than the decision-making of the consumer wanting to get the thing that he or she wanted to get and getting it accurately, is that you start to valorize their internal processing much more than the trademark system ever really intended to do so. And the easiest example of this, here we go, the violence, right. The easiest example of this, I've got hundreds of these if you care to buttonhole me after the talk. But the easiest example is the dilution infringement, right? We all know that the dilution infringement under the FTDA and the amendment subsequently says that thou shalt not dilute, that is to say tarnish or blur a famous mark. We've seen examples earlier today that's been adopted in lots of other countries. country is well known, and so on and so forth, right? We all know that this came about as a consequence of the trademark lobby wanting to extend its influence into these situations. It's outrageous that Tiffany should have a situation where it might be forced to confront the fact that a strip club is open with the name Tiffany's, and that somehow it should be an actionable harm. It's a simple property and gross or business reputation protection. It has nothing whatsoever to do with the consumer confusion, right? And yet, and this is the cute little trick, and it's the cute little trick that the Law and Economics consumer search cost theory did with dilution. It said, no, there is a consumer confusion problem here, right? Trademark law even the dilution action is still about consumer confusion. The way that the consumer is confused is this. Jacob Jacoby, a marketing professor at NYU Stern School, does some tests with experimental subjects, and he shows, he exists, I'm not making him up, right? So Jacob Jacoby takes you or some other experimental subjects and shows you some allegedly dilutive marks. Dogiver, for cute sort of dog chocolates. I can't remember the other ones, but take that as the example. He then shows you the Godiva mark, right, which is the famous mark which Dogiver is referencing. And it turns out that it takes you some 60 milliseconds, give or take, 60 milliseconds longer to recognize the Godiva mark than an unprimed sample takes. That is, those people who were not exposed to the Dogiver mark will be able to recognize Godiva 60 seconds faster than you're able to recognize it. Aha, says Jacoby and Lemley and Dogan and others. That, right, is the way in which we can say that the dilution action is related to the consumer, because the consumer's search costs go up by 60 milliseconds when they are exposed to a dilutive mark. And you got to say, well, yes, if you think that consumer search costs are the problem that the Trademark Act was intended to fix. But if, like me, you don't think that, you might say, well, that 60 seconds might be the time that it takes to get the joke. And that's good because people like laughing the last time I checked. And the last time I checked, the Trademark Act wasn't intended to stop people from having a joke, or even actually to have to think harder. 60 seconds longer for recall. Okay, so the point about this is that I think that the emphasis upon law and economics, law and economics is not of itself the problem. What it does is it provides a convenient cover for basically the business interests of famous mark owners and mark owners generally, and those interests are fine. I'm perfectly happy with it. Yes, I'm a communist, but I play a capitalist on TV, and I'm happy to grant them that they should have some interest of some description. But if that's the case, then that's the argument that they need to make on their own merits. They can't say, no, it's a consumer confusion problem. Okay, we're actually, what we're doing is we're granting marks that are famous marks this broader protection because consumers will somehow be confused. They're not, right? If you want to make the case that we need dilution, right, then you make the case that, oh well, we're going to hand this lottery windfall to famous mark owners because we just like them a lot, right? Or they'll go somewhere else, or whatever the particular argument is. We need to provide a public subsidy to famous mark owners by granting greater protections. Okay, I'm happy to have that debate with you, but don't do it under the aegis of that it's about consumer confusion, because it's just not. So the point that I get to at this particular stage is this. I actually have a drink. You don't have you can have a drink. Now's a good time, right? It's actually written up there. My RA did that. So the point that I'm trying to make is this. Consumer confusion of itself is not enough. Right? We need to be thinking about what is the nature of the actionable harm. And the nature of the actionable harm is the situations where consumers are confused and cannot make the appropriate decision in relation to the consumption that they're seeking to apply the brand to. That doesn't necessarily mean that it's just that we're going back to the Lanham Act being simply the passing off or palming off action. Okay? It's broader than that. So, for example, In areas where we're talking about things like, you would think, sponsorship and affiliation, right, is not something that would be covered by this. We all know that this is now part of the confusion action, and you would say, well, no, this particular approach that I'm pushing here would not allow for a situation where a plaintiff could get ticked off by situations of sponsorship and affiliation. But no, in fact, there are lots of situations where consumers might have meaningful confusion in relation to their consumption decision that relates to sponsorship or affiliation, some kind of imprimatur that's granted to the product that they seek to buy, right? That actually does generate an actionable harm. So the example of the Kennel Club case, where there was a producer of dog food, right, who slapped the Kennel Club of America or whatever it was on that, because there is the assumption that the Kennel Club of America is so high end, cares about animals and so forth. That would mean that consumers would think that this had been passed by the quality inspection processes of the Kennel Club, right, and so therefore their purchasing decision would be influenced negatively by the presence of this thing, and so that should be actionable, right? They've actually not got what they thought they were going to get. So it's actually what this does is it provides a necessary brake upon the inevitable expansion of the trademark system, right? It brings it back to what the trademark system was intended to be in the first place, right? And it does so without having to introduce these really arcane and what I've suggested incorrect views about the way in which law and economics has influenced the particular concern about what we think of when, or what we really should be thinking about when we're thinking about consumer confusion. So then in the 3 to 4 seconds that I have remaining in this presentation, I want to ask how might this apply to the topic of today's presentation, or all of the presentations earlier, and that's how does this relate to the domain name system, and how does it relate to all of the extensions which are being proposed here. I have to admit that this is the bit where I shuffle my feet even more than elsewhere and wave my hands and go, look over here, because I don't have an answer to that. I particularly don't have an answer to that because I'm stuck in a moment of revision, right, of a cognitive dissonance of myself. I am, as I've disclosed earlier, a panelist for WIPO. I got into that process thinking, yes, this is all good. I'd rather be in the process keeping them honest than out of the process simply criticizing. I ordinarily sit outside of the process criticizing. That's my job as a law professor, right? But I thought I will do this. And there have been plenty of times when I was perfectly happy applying the terms of paragraph 4 of the UDRP to the situations that were presented to me as a panelist, and I applied it in a way that I was taught as a lawyer, and all was fine, and I thought that was great. The more that I've heard today about the way in which the system operates, even the way in which I operated within that system, the more I think that there is really a fundamental problem in relation to the UDRP and all of these things. It goes back to the earliest kind of cyber libertarian critiques of the application of the trademark system to cyberspace. I never thought that I would be bringing up these arguments again, and yet I find a real resonance with them as a consequence now of what I think the trademark system should be about. And that is that it doesn't seem to me to be objectionable to allow people to reflect your mark in the domain name space. Really at all, the more I think about it, at all. Because there is no scarcity of resources. It is perfectly possible for Tiffany's or Coke or whatever to reflect their domain name within that space, right? It is no longer tied, the domain name space is no longer tied to any expectation on the part of consumers to that I will go to Coke.com and I will get Coca-Cola, Right? I go to Coke.com and I get pornography. Okay, we should regulate that because people shouldn't end up being exposed to pornography or religious zealotry or whatever. Pick your topic, right? That's fine. We can regulate that separately from the trademark owners should be the only ones entitled to represent their names within the domain name space. I don't believe that to be true anymore because I don't think any consumers are harmed by it. If we have a genuine commitment to consumers, right, which I think we should, then actually I think at the highest level I'm just going to say, you know what, I don't see a problem. And we should scrap the UDRP and allow everyone to apply it in the normal way. I know it's not going to happen, right? I'm not an idiot, right? But I want to throw it out as a topic for conversation afterwards. Say, you can ask me about it, or you can criticize me and say it's absolutely wrong or whatever, but I think that there is an arguable case to be made to say that we have completely gone down the wrong track with all of these protections of trademarks within the domain name system, and that a much more justifiable approach to it would be to scrap it because consumer decision making is not influenced by it really at all these days. If, of course, you tell me that consumers are influenced by it, then in fact, Merrill Scraggs from Skokie, Illinois, right, once purchased a drink incorrectly as a consequence of a domain name that was registered, right, to somebody who did not hold that trademark, then I will grant you that, and I will say, yes, let's regulate it. But until that particular point, I'm not prepared any longer to support this. I'm not going to go so far as to say I'm going to resign my commission as a panelist for WIPO as a neutral, although I've been thinking about that for a while. Okay. I don't think I have anything else to say, and I'm getting the wind-up signal. In fact, I'm getting the cut signal, so I will leave you there. Thank you.
You gonna give me some hand signals? Or some? Oh, your paper even. Beautiful. I'm gonna back you up with my little timer, but you also. Can't hurt to have two. Hi everyone. So Jackie asked me to come and talk a little bit about a topic that I think is probably moving towards some of the future implications of some of what we've been talking about today. Going beyond domain names to other kinds of signifiers. Because you'll notice that the title of the conference is domain names and signifiers. I think actually signifiers got first billing. So we're not only talking about domain names, and what I'm going to be discussing in my remarks here is to do with other of the kind of cyberspace signifiers that are worth thinking about. I'm going to talk about two things. For some of the time, I'm going to talk about an article that I just completed. It's just been published in the University of Illinois Law Review, and I'm going to tell you a little bit about what's in there and how it relates to what we've been talking about today. And then towards the end of my remarks, I'll also make a few comments about what my next, still very early in its germination stages project is going to be that jumps off that, and I may pose a couple of questions, and we'll be interested in hearing what you have to say about them, either in Q&A or when you have a brilliant brainstorm later on and want to send me an email, that's great too. So the Illinois article, which I'll talk about first, is it's about social marketing. Social marketing, as I define it in the paper, is a form of something that a wise professor named Eric Goldman called online word of mouth. It's a particular way of harnessing recommendations to sell stuff. And so in its simplest form, social marketing is, Eric and I, presumably, let's say Eric and I are friends on Facebook, and I go and buy something from Amazon or rent something from Blockbuster, and Amazon or Blockbuster has a mechanism to, without further action on my part, tell Eric and all my other friends that I've made this selection. Why do they do that? Because they hope that by telling Eric about it, they're telling someone who is likely to have tastes somewhat similar to me. After all, he's my friend. And hopefully someone who will pay more attention to that advertisement because it comes with my implicit endorsement attached. Bill's a well-read, wise individual, and he bought this book, so maybe you should too, is the implicit message in there. That kind of social interaction and discussion of recommendations, if designed properly, is a marvelous thing, right? It's what will enable the long tail to function that we've been hearing so much about. It's a way of sharing information and creating more informed decisions. It's a way of building community around purchasing decisions. Designed properly, it's wonderful. Designed poorly, it will be a problem. And that's what I talked about in the article. There are at least 3 kinds of problems that could arise if it's done badly, if it's done without the authentic consent of the person who's supposedly doing the endorsing. And those 3 problems are, the title of the article, disclosure, endorsement, and identity problems. What do I mean? So first, there are disclosure problems. Right? Maybe I don't want Eric to know about this book that I've chosen. Right? Maybe there are private details or facts about me that are going to be disclosed without my authorization to other people as a result of this mechanism. And it's not better that it's only my friends who get this information. It's worse, right? We think of privacy in terms of privacy to the whole world. And if it's a smaller number of people, maybe the harm is diminished. But if those people are your friends, then in fact, that will have a heightened impact for its seriousness. So there could be disclosure problems if, without my permission, this information is disclosed to others. There's endorsement problems, right? There's a serious information quality problem if Amazon tells my friends that I like this book and implicitly I endorse this book. The fact that I purchased it might not be an endorsement. I might be buying it for a friend who I know likes this terrible author. I might be buying it because my professor assigned it to me. There's all kinds of reasons that I might buy it and turn out not to like it. I might buy it on a lark. There's all kinds of reasons why this might not be accurate information about my tastes. This might not really represent an endorsement. And yet, by presenting it in that way, you're polluting that recommendation ecology I was talking about. If I'm not making a voluntary decision to issue an accurate statement of my endorsement, then you can't actually be sure that I really do endorse the book. Moreover, if you can start doing this without permission, you're probably going to greatly increase the quantity of these messages, right? You can have a spamification of these endorsements to the extent that if people start to receive bunches and bunches of them, the influence of any of them will be diminished. So between the possibility that some endorsements that are not fully voluntary will be less than fully accurate, they won't represent my actual enthusiastic recommendation. It won't be something that I loved enough to go on purpose tell my friends about, right? So between the accuracy problems and the increase in quantity, what I think you would have is a serious problem in information quality. You would have a bunch of endorsements going out that were no longer reflective of reality. People would be, in the short term, poor Eric might buy this book that is terrible and that I would never have advised him to buy. In the longer term, Eric might quite wisely decide to start ignoring all of these recommendation messages, and that would be too bad, because there's prospects for good information out of those kinds of messages. And the third is an identity problem, right? We have this right of publicity, we have an appropriation tort, we have a long-standing understanding in the law that people should have control over the commercial use of their identity. I think in most individual cases, one of these incidents occurring is unlikely to be an earth-shattering event that destroys your autonomy. I think that there's a reasonable argument that in the aggregate it could start to become problematic about people's control over the exploitation, the commercial exploitation of their personae. So those are some of the problems I see emerging from this kind of use of a trademarky endorsement, a signifier about my supposed preferences distributed to my friends. The next thing I do in the article is talk about what different sort of legal models are out there to talk about these different kinds of harms. And as you may have been thinking when I laid them out, lo and behold, there's some law about all of these kinds of things. It's flawed in different ways. It has various limitations and shortcomings. But none of it is really tailored for this kind of situation, right? We have privacy law against deeply offensive disclosures. We don't have anything like PIPEDA in Canada, but in the US we have some tort and statutory protections. But these are not those kinds of disclosures, right? We have lots of concern about false endorsements, the sponsorship and affiliation things that Dan was just talking about in trademark and unfair competition law. But most ordinary people are not a trademark. I'm not famous enough to be a trademark myself, and we want to probably discourage, as Jackie Lipton's and other people's work demonstrates, we want to discourage any more blurring of that boundary between ordinary people's personal names and identities and a trademark structure. There's rights of publicity and appropriation torts. Those are getting maybe a little bit closer, but remember I actually said that the rationale of control and autonomy was one of the more silly ones that you could come up with as a harm. So it's sort of problematic that that's the overlap. So what we're left with is a situation of a potential harm and no obvious tool in the toolkit that works for it. So I think that leads us to a couple of conclusions. The first is, I talk about in the article that there are potential best practices that you could draw advice from those legal structures. Not import them wholesale, but derive advice from how to design some best practices. And the biggest piece of advice I draw from all of those areas of law is the significance, the importance, the centrality really of authentic consent. Right? All those problems go away, poof, if I really actually meant to suggest the book to Eric, right? Then any disclosures that are embodied in that recommendation are disclosures that I'm making voluntarily and that I should be able to make. Any information quality problems are resolved. I'm now making a voluntary decision to tell Eric about the book and recommend it. Any concerns about my control will evaporate. So by making that consent decision central and developing some best practices about what consent means, you can make a lot of those problems go away without actually using any of those tools in the legal toolkit, but getting advice from all of them. I talk a little bit about in the article about the possibility that a regulator like the FTC or similar regulators might want to, in a lightweight way, try and promulgate those as unfair competition norms or standards. But I don't think that we need to start creating any new sui generis law around this problem. Some of what we've been talking about today is such sui generis law for this kind of a technological problem. The potential misuse of a signifier and the resulting harms. And it makes me wonder whether if we'd gone down a path more like what I describe in the case of domain names, we might not have some of the controversies that we have now. I'm not quite ready to go as far as Dan does and say, scrap the whole thing, but I do wonder if a separate body of rules all its own for that problem was the best response. So working on that article, I'll tell you a little bit about the next, and then I'll stop there. So one of the real problems you see emerging with bad social marketing practices, things like the original version of the Facebook Beacon initiative, which you might remember from about almost 2 years ago now, but at one point Facebook rolled out this new project where partner sites, when you visited them and you were logged into Facebook at the same time, apparently many Facebook users just never log out of Facebook, just keep it in the background as a logged in resource. If you went to another site while logged into Facebook, that site would start sharing all your information about what you do on that site with friends in their news feeds. And there was a big uproar raising a lot of the issues that I talked about in the article. Okay. That's one of the problems, is that it was putting words in people's mouths, right? It was presenting as a communication authentically originating with me something that was not originating with me. I want to think a little bit in the next project about the other side of that. And this gets us back to some of the online signifiers as well. What about if the person who's doing the talking isn't me at all, but is arguably pretending to be me? Does this sound familiar? Does this sound possibly like domain names or like trademark disputes of the past? But Carl made a sort of passing reference earlier to who's watching out for Twitter names, and that's exactly what I'm starting to think about. Right? There are now, in a socially connected I don't like the phrase, but Web 2.0 environment, right, where we're all talking to each other, and we all have these various screen names, handles, avatars, and pseudonyms through which we're doing that, it's becoming increasingly easy to impersonate another person. And there's accounts of it that have started to bubble up in the courts and bubble up in the media. So St. Louis Cardinals manager Tony La Russa filed suit against Twitter because somebody was tweeting under the handle Tony La Russa, pretending to be him, and saying some things that are not the sorts of things that Tony La Russa would say, including some offensive things, including making fun of the death of one of his players earlier in the season. Right? So I understand why he was very angry. He is a celebrity, and so he was able to bring his suit against Twitter as in part, trademark action, not just privacy or intentional infliction of emotional distress or some kind of appropriation tort. But he actually brought trademark and right of publicity claims against Twitter. Moreover, because intellectual property is carved out from Section 230 immunity, he argued that he could bring the suit against Twitter, and Twitter couldn't rely on the kinds of protections for liability from user-generated content that they normally would, because intellectual property has that special status. And I think what we're looking at now is a whole constellation, thanks to the interactive setting of user-generated content combined with social media, a whole new constellation of identity signifiers, right? Intermediaries like Twitter and Facebook are thinking of this as a way to finally monetize the networks that they have, and are offering both people and corporations services to authenticate that the person who's supposedly presenting themselves as you is really you. So they're imagining a world in which there might be a bunch of Tony La Russa Twitter names, but one would have the special imprimatur of Twitter as being the real Tony La Russa, who's actually the manager of the St. Louis Cardinals. Even if the things that the other imitators are doing is illegal, which it may or may not be, even if that's the case, of course, Twitter is presumably free to offer this extra protection. Locksmiths and Medico are able to sell you locks as extra protection, notwithstanding the fact that burglary is illegal. But I do wonder whether we are going to see, and in fact I speculate we are going to see, a lot more pressure, just of the kind that Jackie and others have been concerned about, to further convert individuals' identities into protectable signifiers that are trademark-like or right of publicity-like, notwithstanding the fact that their absence there's not necessarily any commercial aspect to their identities, notwithstanding the fact that under traditional trademark law they're not protectable. And I'd like to draw some lessons from the frustrations of the domain name experience and avoid repeating some of the problems that we've encountered in that space when we think about these new kinds of handles, these new identities. Now, impersonation can be harmful. It can lead to identity theft. It can lead to deception, to defamation, to confusion. It can be an affront to the individual whose identity is being hijacked. So presumably there are things that need to be done about that structure. And we need to determine if a legal response is called for, what would be its shape. But what we want to avoid is to repeat the mistakes of the trademarkification of a whole new universe of signifiers. And that's what I'll be working on next. So thanks.
I wish. I will be talking to zombies on Friday afternoon at 5 o'clock. Where the heck is it? This one? Oh, there it is. Okay, this is different. How do I maximize this window here?
Press F5.
F5. Lovely. So having the honor of being the last speaker here, I will say the final thank yous to the conference organizers and Jackie in particular for inviting me and for putting on this event. I have a healthy respect for how hard it is to put on the events. Sometimes you just think it's, get a room, order some food, and invite some speakers, and it's done. Somehow it always seems to take far more time than that. So thank you for all the effort. I have a lot to say on signifiers in cyberspace. And for those of you who've heard me before, you know that I'm fairly repressible and rarely lost for words. But the particular topic here for this panel stumped me a little bit. The wording, and unfortunately I don't have it handy, is Online social marketing and cognitive theory. Online social marketing and cognitive theory. And I'm not quite sure what that means. So it stumped me. It did at least force me to let go of all my past presentations I could have recycled here. So you are getting something fresh, which is both good news and bad news. As a world premiere, we'll find out all the bugs in it. But let me just tell you, this is riffing off the theme of consumers and cognitive associations. I realized actually I didn't really want to talk about the consumers today. I want to talk about the battle for consumers today, and all the different ways in which the things we've been discussing over the course of the day relate to big battles that are taking place. So I have a very descriptive talk here for you about the battles that are taking place over consumers and their attention and their dollars. And I have a diagram here. Now, there's been an interesting meme that's developed within the scope of this conference about putting one's picture on a slide. Obviously, Professor Lee felt uncomfortable with that. Professor Farley felt comfortable with it, but only in a caricature form. I wanted to make sure we had a devastatingly handsome model for my slide, so I figured I should go to the places I knew best to find one. So we have a consumer here, a very good-looking consumer, but we have a consumer here. And I was thinking about how this consumer effectuates their consumer preferences in the world. Dan was talking about consumer decision making, and so what I'm looking at is how consumers communicate their interests over the internet. So I'm going to take you through a few different stages here. So consumers will typically use a hardware device of some sort or another to connect to the internet. Here we've got two examples. We've got a laptop computer or a cell phone. I would love to just merge those two diagrams because I really don't understand the distinctions between them anymore. But we have some hardware that enables people to get access to the internet. Then they need some service provider, some connectivity provider, the internet access provider or the carrier, that gives them the connectivity service and then also interfaces with the rest of the world. So I've picked three examples of people that we might interface with, Amazon, Facebook, and Google. But really, actually, this is a pool of millions or hundreds of millions of websites that someone could go to. And my argument to you is that when we think about this, I start at my end and I go all the way down to these destinations. But if we think about it, actually, this is an inverse pyramid from who has the best information about my consumer preferences. The people at the end, the destinations, have the least amount of information about my preferences. And if we move further upstream or back to the left on this chart, we get better sources of information. Who has the best perspectives on what I want as a consumer? I do. It's up here. This is the very best place. But my hardware that I use to connect to the internet, my laptop or my cell phone, whatever hard drive I have, sees everything that I'm doing in a computing environment. It has the full universe of things I'm doing, online, offline. It sees a lot. As you know, if you were to get access to somebody's hard drive, you would be able to figure out their lives. Today, now, it would be a full reflection of their lives. Now, when I'm on the internet access provider sees everything that I do. So they have a pretty good data set of my interests because they don't get to see what I'm doing when I'm offline, but they get to see everything that I'm doing when I'm online. And what's interesting then is that when we think about the massive data sets that everyone freaks out about, Google or Amazon or Facebook, they know so much about me. They sure do know a lot about you, but they actually only know when you're dealing with them. They don't know anything else that you're doing. A paradigmatic example is Amazon does not know when I put something on my wish list at Amazon and then I decide to go buy it from half.com. It still shows up on my wish list. I still want this. Actually, I don't want it anymore, but Amazon doesn't know that I've transacted that purchase. My internet access provider could know that. My hard drive could know that. And of course, I know that. The people at the end of the process, the destinations, don't. Now, in fact, we could draw the very end here on the right differently because we could say actually Google is often interposed between the carrier and the destination website. So we might draw the boxes differently. But the point is that the people at the end of the process actually have the least data sets to rely upon in making decisions about of understanding the consumer preferences that I might have. So what I'm going to do on the next slide, and I tend to be a PowerPoint minimalist in this sense because I have a total of 2 slides for you today, is take a look at some of the battles that are taking place between each of these various individuals or each of these different categories of people who are all helping me accomplish my consumer preferences to try to get the better source of information in order to understand my preferences better and to make more money from it. So let's talk about 3 themes. That's all I got for you today. Theme number 1 is that trademark owners want veto rights on any associations with their trademark. Ray Koo made that point this morning. We've heard the theme come up in a couple of different ways. But what we're seeing is that trademark owners are saying to each of the people in this chain as much as they can, if you are seeing my trademark, I want to tell you what you can show in response to that trademark. I don't want you to make that decision yourself. So, for example, we have the keyword lawsuits that the trademark owners are bringing. It's actually very hard to keep track of them all. There are currently 9 pending against Google, as far as I can count them. There's at least one big one against Yahoo, the American Airlines lawsuit. And what we can do is we deconstruct those lawsuits. What the trademark owners are saying is, search engines, you are making choices about what to present to the consumers when you see my trademark. And if I'm okay with what you're presenting, then go for it. But if I'm not okay with it, I want the right to kibosh it. I want the right to take that away and say that's not an appropriate thing for the consumers to see. So those lawsuits are really actually just veto rights. The trademark owner doesn't sue to say, I want to force this particular information in there. In theory, they would if they could. They don't have good legal grounds to do that. So all they're able to do is excise content that they don't want, or content or advertising that they don't want by saying that's an inappropriate association. We also have this in the context of the state anti-keyword laws. This was one of the rashes of moral panics that we have. The panic in the middle part of this decade was against adware. This was client-side software that would live on your hard drive, monitor your behavior, and trigger advertising that would be putatively responsive to whatever it saw. So going back to the model here, notice what was so interesting about adware. Adware wasn't saying, I want to wait till you get to Amazon, Facebook, or Google. I want to get onto the hard drive over here because I'll get to see more information about what you're interested in. So they were trying to move down this process or move up the pyramid closer to the source of the consumer preferences. And what a few states said is there are rules about how you can monitor people's behavior and trigger pop-up advertising to you. So Utah has a law in its book, the Spyware Control Act. Alaska has a law in its book, I called SB 140, that basically say that a adware vendor cannot use a trademark to trigger pop-up advertising to the consumer. Now, what's interesting about this, depending on how you read the statutes, is that consumer consent is not sufficient. It's not the consumer's decision about what tools are useful for them. It's the trademark owner's ability to decide when that software can appropriately make those associations. So once again, we have an example here where it's the trademark owners usurping their ability to grab control over what consumers see. Okay, the second theme I want to talk about is that the data sources are fighting with each other as well as with the trademark owners. Let me give you some examples about that. So, for example, you may be familiar with the concerns about deep packet inspection. So going back to my model here, Deep packet inspection is when the carrier says, I'm going to watch the traffic that's going over my network between the hard drive and these destinations, and I'm going to infer consumer preferences from those, and I'm going to trigger advertising based on the traffic that I'm seeing by understanding what people are searching for or looking for online, and then making my judgments about what to present. There are some legal concerns about the ability to do deep packet inspection, that the carrier or the internet access provider may not have the legal rights to understand the traffic that they're processing. They may be expected only to process it in a quote neutral fashion. But what happened is that the deep packet inspection reaction was not just from consumers saying that's wrong of my internet access provider to mismanage its relationship with me. There certainly was plenty of people thinking that. But I would also point out that there was a fair amount of grumbling on the part of the people at the end of the terminus, saying, if you do that, then not only do you see everything that I see, but you see everything my competitors see, which means you'll have a better data set than I will, which means that you will be able to do a better job assessing what consumers might want than I can. So when we heard the rumblings about deep packet inspection, for example, it was not simply, let's protect the consumers. It was also potentially the website saying, if I'm Amazon, I don't want you to know that the book has already been bought from half.com because I don't know that. You're now in a better position than me to make money from that consumer. And in general, if you look at the trends on opt-in privacy laws, in fact, some of the big players in the internet space have come out in favor of opt-in privacy laws. Google has, for example. Some of that is actually about rolling up competition behind them. Notice that the small companies are not fans of the opt-in privacy laws. It's only the big companies because they have better data sets than their competitors. What you want to do is you get the relationship with the consumer, you mass this database, and then you want to fold up the tent and close the doors behind you. So a lot of these battles are not about what's in the best interest of the consumer. These are actually battles among competitors saying, I'm going to try and keep my competitors from having robust data sets to compete with me. Another example of the ways data sources are fighting with each other is that websites are trying to learn more information about a consumer than they just see when the consumer is interacting with their website. Let me give two examples. First, Bill talked about Beacon. Beacon was actually, if you think about it, from going back to this architecture, Beacon was Facebook saying, I want to know when people are transacting with websites, not me, and then I can use that information in order to create commercially valuable exchanges. So what they're trying to do is find a way to reach out to data sets that they weren't otherwise seeing. Beacon was just a big network for gathering information that Facebook could commercialize. Similarly, you may be familiar with the retargeting process. So what happens with retargeting is if you go to a website and you put something in your shopping cart and then you abandon your shopping cart, that e-commerce retailer will say, I'm going to look and see if I can find that consumer on other websites, and I'm going to show them an ad saying, hey, come back, I got a better deal for you. Or come back, you forgot to close out your deal. So for example, I was looking at watches online. I put something into my shopping cart. And now everywhere I go online, I'm getting ads from Amazon. Come back to our watch store. How are they doing that? They have, it's actually through these ad networks set up a tool that make it actually fairly easy for now sites to be able to say, when I saw a consumer one time, when I see him again through these ad networks, present my ad to remind him to come back to me. Again, this is the way of a site like Amazon saying, when you're on Facebook, I want you to, I can't see what you're doing there, but I can at least remind you to come back to me. They're trying to extend their reach beyond where the database allows them to go. And the last example I'll point out about data sources fighting with each other is a meme that keeps coming up. This is something that's a perennial. The battle over people's address bars. So for example, back in the 1990s, you would typically only have one bar on the top of your browser screen. And that bar would be an address bar where you would put in a domain name and you would hit enter and you would expect to go to that domain name. Now, because you are entering something that is of putative interest to you, if someone can see that, they can try and say, well, how about thinking about this other place you might want to go to? So, for example, some of you may remember Real Names, where Real Names was saying, when I see you put in a term into an address bar, I'm going to say, did you also think about all these other people that you might want to go take a look at? This is this battle keeps coming back now in the Google Chrome Omnibox. I don't know how many of you are using Google Chrome. I use it. What happened since then, as you may know, since the kind of crash of domain names, is that now everyone tries to get search bars onto your desktop. So I don't know how many search bars you guys have in one time. My wife has 5 different search bars that are presented at the top in addition to our address bars. So there are 6 different white boxes that she can fill in to try and say, here's what I'm looking for and here's where to go to. It's nonsense. It's absolutely crazy. Google Chrome eliminates all that. Google goes back to the one box and says, this box, you can enter an address as in a domain name, or you can enter a search term and we'll figure out which one you mean. So what now Google is trying to do, going back to this screen, is that Google's saying, I don't want to wait till you come to my website to do the search. I want to get the search going when I'm at your hard drive. They're trying to push back the place at which they're seeing what you're doing and trying to figure out your preference earlier in the process to get closer upstream to the ultimate source. Okay, the last point I want to make, this is a point that we've touched on briefly throughout the day, but the real reasons why these battles matter is because in order for somebody to help us as consumers make matches, they need to understand what trademarks are interested in, and then they need to use that accordingly. And in fact, what we expect as consumers is that the intermediary that we are associating with, that we're relying upon, is going to read our mind. They don't want us. We don't want to have to explain in gory detail everything that we want. We want it to just magically be inferred. And in order to do those inferences, the intermediaries have to say, what brands are you interested in? And let me think about if there's other competitive substitutes that might be useful. I don't even have a phrase for this yet. But so, for example, you may know that, that there's a number, some percentage of the searches that we do where we use a trademark. We're not interested in finding the trademark owner. We are using the trademark as a proxy for that entire class of goods. Let me give you the example. I think you'll all recognize it. I think everyone, maybe some of you students might not remember this. The clapper. Do you guys remember that? Yeah, all right, let's get those blood flowing on a Friday at 5 o'clock. The clapper, clap on, clap off, right? If you wanted to find the competitors to the clapper, what terms would you use as a search term? I don't mean to stump you. I don't mean to pose a brain teaser here, but I am unaware of any synonym that we would use to describe the class of goods called the clapper. We have this in other areas as well, as you may know, pharmaceuticals, for example, that are subject to patent protection. The trademark is the only brand that's used to describe that particular class of goods because there's only one good in the marketplace for a time. We run into that. But the clapper, I think, is a better example because there is nothing that restricts the entry of alternative clapping devices, but we don't know what to call it. So when somebody puts the word clapper into a search engine, they might be looking for the branded version of the clapper, or they may be looking for the class of goods that the clapper represents. We want the intermediaries to figure that out, and to figure out that we might sometimes mean the clapper, the one, or we might mean the class of goods. And if they can't use trademarks in order to make those determinations, then they're not actually going to be able to read our minds. So what we've seen in the battles between trademark owners and intermediaries, between data sources fighting over each other, is we're seeing a bunch of walls being erected around data sets where people are trying to say, let's make the searches harder to give consumers what they want. Let's take away tools that intermediaries can use in order to figure it out and read consumers' minds. We're basically going to erect a bunch of walls that say you have to do things the harder way than you might otherwise choose to do. So for example, the anti-keyword advertising laws that I mentioned here, these anti-adware laws. These adware laws, look, I don't like adware. I wouldn't choose to use it. But if somebody found adware valuable, these laws take away from consumers the choice to actually use that. That's a way of erecting a wall saying trademarks are no longer a useful tool to help make matches between producers and consumers. They're actually stylized when they can be used only in a particular way. I wish I had some greater broad insight about how we deal with this. As I said, this is a talk that was manufactured just in time, and I only hope to at least cover the descriptive thing of what's really going on in some of the legal discussions we're having, the battles between various people, which I think sometimes get overlooked. Sometimes we think about this as purely about consumer protection. I think that's really a mistake if we focus on that level. And with that, I'll draw it to a close. Thank you very much.
Great, let's go ahead and get some Q&A going. Somebody has microphone, yeah.
I have a note for each of the three of you, briefly. Wow. Eric, it's a sound-activated light switch.
Sound-activated light switch, okay, terrific. And your Google results for that are?
Number one is the clapper.
Comes up with the first sponsored link. So Clapper's right there at the top. I mean, it's not that Clapper is clearly a quicker, easier term.
And it's more likely to be accurate. In other words, we're not quite sure what we're going to get with a sound-activated light.
Right, and I'm reverse engineering, right? I'm going, what do I call a clapper, right? Which is the reverse of the problem that you're describing. Bill, I think that you're really onto something. Have you talked to Devin Desai, who seems to be working on almost exactly the same theme that you are?
Yes, thank you, I have.
Okay. The question is for Dan.
The real question. Oh, all right. Here's the wind-up, folks.
Here it comes.
Actually, I agree with what you've got to say about just about 100%. The piece of the puzzle that I didn't hear you talk about, so I'd like to get your reaction, is this. You talked a great deal about the classic problem of a consumer who wants to know that when he or she makes the buying decision that he or she's going to get what it is that they want.
Right.
The other piece of this puzzle is that relationship, that accuracy interest, wants to be both consistent from the trademark owner's standpoint and from the consumer standpoint across a large population of people, right? So that all consumers of that good want to have that same accuracy interest vis-a-vis that same producer.
Okay.
And all of those consumers, or some big portion of those consumers, have that accuracy interest when they're talking with one another. So there's a connection between what you're talking about and with what Bill is talking about. Right? And so the question for you is, does your sort of narrowing and refining interpretation of what trademark law should really be concerned about, does that extend to the horizontal communication interest as well as to the vertical communication interest that you're talking about?
Well, Bill seems to have a better understanding of it than I do. So I haven't thought a lot about it. I mean, in the sense, I don't know that there's any problem with people talking about that, about the brand or about the mark, in any social media or any other form. So is that's I take it that's not the question you were asking.
No, it's not. It's not that the trademark owner cares. Not that the trademark owner necessarily wants to enforce a consistency of meaning when consumers are talking to one another, although you could actually imagine a trademark owner trying to do that.
Right, yeah. They want that, yeah. Just talk about ours, not in Texas, you shouldn't call sodas Cokes, right? Right. At least according to the Coca-Cola company.
But the question instead is, it sort of gets to what Bill was going towards, which is whether consumers themselves have an interest in consistency of meaning for marks that is, in any sense, beyond sort of the accuracy in purchasing decision that you're talking about.
Let me answer it as best I can, and then we can take it up afterwards, or Bill could actually dive in and give you the answer that perhaps you want. The difficulty that I think that you've exposed is in this particular theory is that it sort of assumes a little bit that consumer preferences are stable and static over time, and that's not true. They get influenced by lots of things, including discussions with my friend Bill here, who is recommending this thing and says, alternatively says no, poo-poo, and so forth. And of course, a big part of the advertising process itself is to try to make the consumers feel better about this. So in fact, the whole the edifice of the advertising industrial complex is intended to change consumer preferences, and I'm sort of assuming that the only thing that really matters is to make sure that the consumers get what they want. That's what the trademark system is about, and it's clearly not just about that. It's about providing this stable source indicator that is used by the advertisers in particular ways. So I think that there is a way in which you can say, you can accommodate. You can say that, for example, as long as consumers can be influenced by the trademark, consumers can be influenced by their friends, can be influenced in the discussion that they're having, as long as in the end, when they're making a purchasing decision or some sort of consumption decision to buy or not to buy, to tell my friend that it's good or not good, recommendation, it does fit in a little bit with what Bill was talking about. Then, as long as those things are not misdirected, then the trademark system is performing an appropriate function and everything else can be stripped out. But I know that I haven't answered your question appropriately, so maybe we can take it up. I just don't. Do you want to answer it?
No, I think, as I was listening to Dan, part of what I was thinking, and Mark McKenna, your co-author, has said in other settings, to some extent, what has happened to the confusion rationale over time has been a consequence of a recognition mostly by judges that there are other things going on beyond source identification when trademarks are in use. There's persuasion and other things that are occurring, and that the investment in that should be protected. And so, confusion got distorted more and more over time. I've suggested to Mark that if you could go back in time, it might be the case that you would wish that you had enacted a dilution law long ago after all, because all of those kinds of concerns, to the extent that you wanted to address them, would get addressed there, and confusion would have remained less distorted. You'd have maybe a more robust dilution cause of action than you have now.
What, on the basis that back in 1946 it was okay to have something which was about unfair competition for business reputation?
No, just based on the fact that the reason that confusion has become distorted through things like initial interest and some might say sponsorship or affiliation. Mark certainly is critical of that now. That it was done out of the motivation for it was a motivation to protect some of the brand value and brand equity that Fume was talking about earlier in the day. Uh-huh. And that given that courts are going to do that, maybe you ought to give them a more cabin structured way to do it, right, rather than give them this confusion rationale and have them distort it over time to address those problems.
Right. It seems reasonable.
To follow up on Mike's question, and maybe I'm not sure if this is what you were thinking about. So to the extent, in referring to Corinne's example of De Beers, right? So I buy a De Beers diamond, and I buy it for a whole host of reasons, and I think I've made the decision and actually satisfied the preference I want. Now someone comes out with that very, very powerful critique of De Beers. And now all of a sudden I'm questioning my decision, right? So the criticism has hurt my kind of after purchase choice.
Right.
Does the consumer? I think my guess is you're very skeptical, as I would be, that a consumers under those circumstances have an independent right to essentially support their prior decisions and protect the value that they ascribe to the marks.
So my initial answer was I don't think that's something which Trademark really wants to get into. Although I would love to see some discussion of it. There is an example which is not so crazy, which is similar to that. That's the area of post-sale confusion, which is a judge-made artifact that says it applies in relation to the thing that I study a lot of, handbags, right? Luxury handbags. And so the argument is that the knockoff handbags you can buy in Canal Street in New York or in Santee Alley in LA or wherever, pick your local knockoff place. The fact that somebody is wearing that woman is wearing that bag somehow affects the woman and the brand owner, the woman who purchased the genuine article and the brand owner who has the Louis Vuitton or Prada or Bottega Veneta or whatever. And the argument is that it affects the market for the genuine product. It's the relevant consumer confusion is not the person who's buying the knockoff bag. She knows that it's $35, it's a knockoff. And it's not the person who is going to go and buy the genuine bag at the Hermes store or the Vuitton store. It's somebody who decides not to purchase a Vuitton bag because of the ubiquity of the knockoff bags and the fact that people who they think of as low class are wearing those bags. Now, the way in which that is theorized in the cases is terrible, right? The judges just kind of go, oh, there's consumer confusion with the potential public, right? They don't know whose bag is real and not, therefore action, post-sale confusion. But you can actually rescue the post-sale confusion claim by, well, I can, right? If you adopt my theory and Mark's theory, is by saying, that in fact the consumer's purchasing decision is influenced by the existence of knockoff bags there. They decide not to buy a Vuitton bag, and as a result, their consumer preferences have not been satisfied. Their purchasing decision has in fact been misdirected. Now, that's really thin. I don't think that is actually the case. I don't think that's an actionable harm, but in fact, it's the closest that I can get to at the moment to actually create a situation where you say there might be an actionable harm for changing people's preferences over time negatively. That is, I was saying initially, the theory sort of seems to presume that the consumer preferences are stable. This is an example of a situation where, in fact, the consumer preferences have been affected. They might have been affected negatively, as, for example, in the De Beers Diamond situation. So, in fact, there might be an actionable harm that the consumers could get together and say, you know what, I'm harmed by this because I was really happy about buying that Vuitton bag and I'm no longer happy about buying it because that skanky hoe over there has got one and I really hate her and all that kind of stuff. I don't think it's a really good claim, but that's the only way in which I think you can sort of rescue post-sale confusion.
Ray, if I can just chime in on this one briefly. The example you gave specifically, I think really sets up a nice interface between defamation and trademark. And I really haven't seen a lot of work done that I can recall seeing, but maybe just not recently, really exploring where those frontiers are, where we want to steer things towards defamation versus trademark. And it seems to me that the example you gave, when it's criticism, if we say, well, it's not defamatory, my initial reaction is, well, we might decide we've already taken care of all the work that we need to do. If it's not false information, we decide that that's now outside of trademark law and it's outside of defamation law, that should be legitimate.
Yeah.
Okay, it doesn't look like there's any more questions, so I'm going to go ahead and turn it over to Jackie for some closing remarks.
And we should thank the speakers on this
Yes.
panel as well.
Thank you very much.
The program says I'm going to make remarks and I'm not going to stay here all night and keep everyone here, but there is one remark that I do want to make. And anyone who reads Mike Madison's blog knows that I'm kind of, not only am I a technology geek, but I'm also a bit of a Stephanie Meyer Twilight geek at the moment, and New Moon is coming out next week, and unfortunately I'll be in Denver. I think you will be.
We'll go see it.
We'll go see it in Denver. It's a date.
They have movie theaters there.
Yeah, we'll go. We'll go see it. That's cool. But
You never know when they'll get
the
it.
reason I wanted to raise that was that one thing that this conference actually reminded me of, and I did all the stuff that Eric said, I did all the nuts and bolts and invited all the speakers and was thrilled that they could come. But when Stephanie Meyer was interviewed about, what was really cool to her about the Twilight movie when it came out, and she said, well, the baseball scene, because she'd kind of seen it in her head, but nothing in her head really prepared her for this great scene with the actors and the music and just how it turned out. And that's kind of how I feel about this conference, because I just called up all the people who I really, really love their work and I really wanted to hear them speak. And I was expecting it to be a good conference, and I don't know about the rest of you, but I have had just the best time today. I mean, this has far exceeded my expectations, and I'm sorry I put you guys on last. It was your flight school later, and that was but it's being webcast, so more people will see it. But I've just, I've had a terrific time. I hope everyone else had. I hope that if you couldn't stay for the whole thing, you'll watch the webcast on our website in a few days. And I'd just like to thank, again, the speakers, my colleagues, and the students who have volunteered and helped out the whole time. And with that, I think we're adjourned. Thank you very much.